Hello and welcome to BYJU'S Exam Prep. Welcome to our weekly explained session. The topic for today is the Enforcement Directorate, which has been making a lot of news in the last few weeks. So today we are going to understand the powers and functions of Enforcement Directorate. We'll talk about the controversy surrounding this organization, and we shall also evaluate some of the provisions of the Prevention of Money Laundering Act. These are very important topics for internal security and as well as for polity. So if you're liking this initiative, do let us know by pressing the like button, share your comments, and don't forget to subscribe to our channel. So let's start with today's discussion and understand all the key facts and all the important analysis that is required with regard to Enforcement Directorate. First, let's begin by understanding why this organization is in news. See, in this year, in 2022, the ED or the Enforcement Directorate has conducted a number of raids around the country. It has conducted raids against cryptocurrency exchanges. It has raided many politicians, high-profile businessmen, companies, and as well as few entities related to political parties and political organizations. And these raids have happened across the country, in Maharashtra, in West Bengal, in Delhi. So across India, there have been several raids conducted by ED, and these raids have gone up in the last few weeks. So this has led to a political controversy that the ruling party at the center is misusing ED or Enforcement Directorate to target the political opposition. So that's the reason why ED is in news. And recently, just last week, the Supreme Court also made a very important observation related to ED. The Supreme Court recognized that the ED does enjoy sweeping powers. But the Supreme Court said that these sweeping powers enjoyed by ED is justified because these extraordinary powers are needed, according to the Supreme Court, to tackle the offense of money laundering. Last week, Supreme Court was looking at the constitutionality of the new amendments that have been introduced to PMLA or the Prevention of Money Laundering Act. In this case, the Supreme Court justified the need for such a stringent law to tackle money laundering, and even though it recognized that ED has wide sweeping powers, the Supreme Court was of the opinion that such extraordinary powers are needed to tackle this serious offense. It's in this context that the ED has been making a lot of news and can be very important for our exams. So first, let's talk about a few basic facts. Let's understand a bit of background about ED. And after that, we'll carry out the analysis. We'll look at the key provisions of PMLA, which gives these extraordinary powers to ED. And we shall also evaluate the powers and functions of ED and talk about the impact it is having on the politics and as well as on the economy of the nation. See, the ED is essentially a law enforcement agency. It's a central agency that's under the central government, which enforces a set of laws that it is supposed to enforce. This organization was set up in the year 1956. It was established as the enforcement unit under the Department of Economic Affairs, which is under the Ministry of Finance. This law enforcement agency is mainly responsible to deal with a few types of economic crimes and economic offenses, which includes money laundering and as well as offenses related to forex laws, foreign exchange laws, and a few other related economic crimes and economic offenses. So as part of this mandate, the ED enforces a few economic laws that have been brought out to tackle these economic crimes and economic offenses. These economic crimes, they are definitely a threat to the country's economic security. It threatens the very economic stability of the nation. And some of these crimes, especially money laundering, can also be a serious national security threat. Is that clear? Money laundering is not just an economic threat, but it is also a very serious national security threat. Because this criminal offense, that is money laundering, it is closely linked with organized crime, and it is also linked with terror financing. There exists a direct connection between money laundering and various types of organized crime, such as drug trafficking, arms trafficking, etc. Money laundering is closely linked with financing of terrorism as well. So as a result, money laundering is not just an economic offense that threatens our economic security, but it is also a very serious national security threat. And because of its links with organized crime, money laundering can even lead to social consequences. It can enable corruption in the government. It can weaken governance. It can affect socio-economic development. If it enables organized crime such as drug trafficking and increases drug addiction, right? Even that would have social consequences. So that is why money laundering is a very grave and a very serious offense. It's not just an economic threat, it is also a threat to the country's national security and to the very social well-being of our society. So that's the reason why there are very stringent laws to tackle money laundering, both in India and as well as around the world. It's in this context that ED becomes a very important and a very powerful law enforcement agency. See, after it was set up in 1956, it was renamed to the ED, the Enforcement Directorate. Initially, it was known as the Enforcement Unit. It was renamed and later it was moved to the Department of Revenue under the Finance Ministry. So that is where ED is located today. It functions under the Department of Revenue of the Finance Ministry. So essentially, it is a multi-dimensional organization that tackles various types of economic crimes and offenses, and its primary focus is on tackling money laundering. So this is what the ED does. And as part of its role, it enforces these laws that have been listed over here. You can make a note of this, can be very important for your prelims. These are some of the laws, economic laws that ED enforces to tackle economic crimes and economic offenses. It enforces the PMLA, as we already mentioned, the Prevention of Money Laundering Act. It enforces laws related to foreign exchange, the FEMA or the Foreign Exchange Management Act. It also enforces a new law that was enacted in 2018 called the Fugitive Economic Offenders Act. This law was enacted with the Parliament after many high-profile economic offenders fled the country and became fugitives. For example, Vijay Mallya, Lalit Modi, Nirav Modi, etc. These were high-profile economic offenders who ran away from the country and became economic fugitives. So to enable the ED to go after them, to go after their assets, their illegal proceeds, and to confiscate their wealth and property, this law was brought out by the government, which added even more powers to the ED. See, the ED was already a very powerful organization because of its powers under the PMLA. So with the Fugitive Economic Offenders Act, more teeth was added to the Enforcement Directorate. Then previously it was enforcing the Foreign Exchange Regulation Act of 1973. This law was eventually replaced by FEMA, and it also acts as a sponsoring agency under COFEPOSA. COFEPOSA deals with countering foreign exchange offenses and Prevention of Smuggling Act, deals with forex crimes and smuggling related offenses. So with regard to enforcement of COFEPOSA, ED has a role where it can sponsor the arrest or the detention of suspects. So these are the primary laws that are enforced by ED, and it becomes very important to evaluate the powers that this organization is enjoying, especially under PMLA, right? To tackle money laundering and terror financing, the ED has been given extraordinary powers under this law. So for the next 25 to 30 minutes, we're going to take a look at all the important provisions of the law which gives these economic offenses, which gives the ED the strength to tackle these economic offenses, right? So under the law, the Enforcement Directorate has been given the powers to arrest the accused, because money laundering is treated as a criminal offense. The law treats money laundering as a serious criminal offense, and empowers the ED to arrest the accused. It can also confiscate the proceeds of crime, the proceeds that arise out of money laundering can be confiscated by the authority. This is where you should have a brief idea with regard to what is money laundering. See, money laundering is essentially an illegal process, a criminal process through which illegal wealth is converted into legal wealth. That would be the most simplest definition of money laundering. The process of converting black money into white. Basically, the process of converting illegally acquired wealth, wealth that is acquired through corruption, wealth acquired through illegal activities like drug trafficking. So any such wealth, even wealth acquired through tax evasion. So if such illegal wealth is getting converted into legal wealth, that process which is employed is known as money laundering. And considering the seriousness of this crime, it is treated as a criminal offense. It's not just a civil offense, and the ED has been given the powers to arrest the accused and to confiscate the proceeds of the crime. The law clearly defines money laundering. It defines what are the proceeds of crime. The wealth generated out of these illegal activities, the wealth being moved around through money laundering is classified as proceeds of crime. And ED has the authority to confiscate those proceeds. It has also been given the powers to search any premise, search any property, search any vehicle or any individual. And it also has the powers to seize these assets, and more importantly, it can attach the proceeds to the ongoing case. The proceeds of the crime, the illegal wealth which is confiscated and seized by the authorities, it can be attached as part of the ongoing case. So such extraordinary powers have been given to ED, and hence it becomes very important to analyze and evaluate the evolution of ED as an organization. Let's carry out a brief evaluation of how ED's powers have evolved since it was established in 1950s. See, after being set up in 1956, its name was changed to the ED. It was set up as Enforcement Unit in 1956. A year later, its name was changed and moved into the Department of Revenue. So back then, this organization was only dealing with few civil offenses related to Forex laws. It was only enforcing the FERA, the Foreign Exchange Regulation Act, and any minor offenses related to foreign exchange, which would usually be committed in the corporate sector, in the private sector, was the focus of this organization. So back then, it was not a very powerful and a feared organization because it was only dealing with civil offenses. It wasn't dealing with any criminal offenses. It was only looking at Forex violations being committed by few corporate entities in the private sector. And also back in those days, we didn't have a well-established private sector or corporate industry in our country. So ED was not actually a very powerful organization to begin with. Then in 1973, the FERA was amended. New amendments were brought in, and through this, the FERA was made into a very powerful law to deal with Forex crimes. And Forex crimes were treated as criminal offenses, and as a result, the ED acquired tremendous powers. Under the Foreign Exchange Regulation Act that was amended in 1973, ED was given quite a few extraordinary powers because now Forex crimes, Forex related offenses were being treated as a criminal offense, as a crime. So this was the first time that ED got few extraordinary powers, and back then it could even arrest people without a warrant. It could enter any premises, any property it could enter without a warrant, and even inspector level officers, that is enforcement officers and assistant EOs, they could go and arrest the accused, the suspects. They could enter any property without a warrant and arrest the accused without a warrant. So clearly this was an extraordinary power that was given back in those days. Following this, the ED overnight became a powerful organization and it started going behind the corporate sector. It started investigating several cases related to Forex violations, and it became a feared organization in the private industry. Many businessmen, many businesses were targeted, and there were even allegations of torture and violation of rights that came up during this period against ED. There were several serious allegations that came up that ED was already misusing its powers, and there were cases of allegations of torture that was coming up, allegations of basic violation of basic rights that were being brought up by the private sector. So there was a period where the ED was a feared organization, that is especially between 1970s and 1990s. So for 2 decades, the ED continued on this path, and it was quite a feared law enforcement agency. But then came the 1990s, and India entered a new era. The year was 1991. India was facing a grave economic crisis, the balance of payments crisis. This crisis pushed India to liberalize and privatize and globalize its economy, and the LPG reforms were introduced. So as India opened up its economy and integrated with the rest of the world, several new types of sophisticated economic crime started happening. New challenges came up in the economic domain, and a number of sophisticated crimes were being committed. So this is when the government realized that laws like FERA are outdated, they are obsolete. They are not capable of dealing with the new age crimes, the new age offenses that were taking place. Several high profile scandals were breaking out in the stock markets, in the banking system. Large scale frauds were being committed. So this was a byproduct of LPG reforms, right? Because as India opened up its economy, it was bound to happen. There would be new age crimes and sophisticated economic offenses that would come up. And also the government realized that a law like FERA was being abused excessively, and there was a lot of criticism against the law because of the allegations of torture and violation of rights. So the government decided to repeal FERA, and it replaced it with FEMA, the Foreign Exchange Management Act, which turned forex violations back into civil offenses. The criminality of forex violations was taken away by FEMA, and it was again made into a civil offense. So as a result, ED lost its powers. It was defanged. Because of the controversy surrounding the organization, the law itself was repealed. And to enable India to deal with the new age crimes, a better and more efficient law was needed, and FERA was replaced with FEMA that made forex crimes a civil offense. So as a result, ED lost some of its authority and powers, and it was essentially defanged by the government. But parallelly, in the same decade, in the 1990s and in early 2000, a new economic crime, economic offense started gaining prominence around the world. That was money laundering. Money laundering came up as a very serious economic threat, where illegal wealth, or basically black money, was being freely converted into legal wealth. This was a global level scandal that was happening, where criminals, corrupt politicians, corrupt officials, tax evaders, businesses, they were all benefiting from it, and they were converting their illegal wealth into legal wealth. This came up as a threat in the Western world, in the industrialized nations, and it also became a threat to developing nations as well. So in this context, in 1989, the G7 countries, the group of industrialized nations, they formed an intergovernmental organization known as FATF, the Financial Action Task Force. They set up a dedicated intergovernmental body to tackle money laundering and to implement anti-money laundering standards. So FATF was set up as a global body that could act as a policy-making institution, as an advisory body that would come out with policy recommendations which would be implemented by all the countries through their national laws. So FATF was set up as a dedicated body to combat money laundering, to recommend anti-money laundering standards to all the countries. Then, as a result, every country was expected to abide by the new FATF standards, and this pressure was already there on India as well. As India also had opened up its economy, and such scandals were breaking out, India was also expected to abide by the FATF standards by implementing these anti-money laundering standards. Parallelly, a link started emerging between money laundering and terror financing, especially through the Hawala routes, through Hawala networks. Terror groups like Al-Qaeda, they had started moving money around in order to finance their terror operations. When the 9/11 attacks happened in the US in 2001, which changed the face of global geopolitics, it emerged that the 9/11 attacks was sponsored through the money laundering route involving Hawala channels or Hawala networks. It's an informal banking method through which money is moved around without leaving behind any trail of evidence. So as this link emerged between money laundering and terror financing, countries around the world got more serious about tackling the threat. Now the FATF was given a second responsibility, which was to counter terrorist financing. Previously, FATF had only one mandate, which was to implement anti-money laundering standards. And after 9/11 attacks, after the link between money laundering and terror financing became clear, it was given a second target, which was to recommend counter-terrorist financing measures. So these standards were supposed to be followed by all the countries, and India finally brought out the PMLA, the Prevention of Money Laundering Act, in the year 2002. That is how India enacted the PMLA. In 2005, the PMLA came into force. It entered into force, and this law made ED the responsible law enforcement agency to enforce these laws against money laundering. So that is how ED once again became a very powerful organization, because right now it enjoyed tremendous powers under this new law called PMLA, the Prevention of Money Laundering Act. This law has been amended several times over the years. It has been amended in 2009, it has been amended in 2013, and even recently it has been amended in 2019. Through these subsequent amendments, India has tried to update its anti-money laundering and counter-terror financing measures to match the FATF standards. These amendments have made PMLA a more stringent law day by day, and it has given even more powers to the ED. The current controversy that we are looking at, the current question about ED's extraordinary powers, comes because of all these changes that have been done. Through various amendments, the law has been made even more strict, and even more powers have been given to ED, which is largely unchecked according to certain legal experts. Many experts argue that today ED has become one of the most powerful law enforcement agencies, and it is considered to be even more powerful than the CBI, and in some cases even more powerful than the NIA. That is one of the arguments made by the critics of the law and those who criticize ED and the way in which it is often used by the government of India. The critics point out that ED has become the most powerful law enforcement agency, which has even more extraordinary powers than the CBI and the NIA. So the fear is that the chances are high that such an organization with unchecked powers and with extraordinary powers could be misused for political reasons. So this is where the controversy arises. The possible political abuse of ED is the primary concern. So now the ED enjoys these tremendous powers, and it's important to take a look at the kind of extraordinary powers that have been given to ED through the PMLA. So let me point out some of these provisions one by one, and at the end of the session we will analyze this entire controversy. To begin with, you need to note that ED has been allowed to record statements from the accused, and these statements that the accused makes in front of an investigating officer becomes admissible as a piece of evidence in a court of law when the case is being prosecuted. So basically the law PMLA is providing for self-incrimination. And if you have read Article 20 of the Indian Constitution, if you have gone through this fundamental right, you would be aware that self-incrimination is unconstitutional. No individual shall be forced to provide self-incriminating evidence against themselves. That's a basic right, a fundamental right. But PMLA provides this extraordinary power where the statement provided by the accused in front of an investigating authority, in front of ED officers, can be accepted as evidence by a court when the case is taken for prosecution. Now, this is a tremendous power, because what if the authorities are coercing the accused? There is a possibility that in some cases, the accused might be threatened or beaten or tortured to provide self-incriminating statements. Right? What if they are forced to give a submission under undue pressure or duress? And what if this is used in court as evidence against the accused? So that is why the PMLA has often been equated with very controversial laws like TADA and POTA. But see, don't forget that we are looking at one side of the argument as of now. Later, we will look at why such stringent measures are needed for PMLA. That is the other side of the argument, which justifies the law, which justifies the powers given to ED. So critics of the law, critics of ED point out that PMLA is as bad and dangerous as TADA and POTA. Those of you who are not aware, these were very controversial anti-terror laws of India back in the 1980s and early 2000. TADA, which stands for Terror and Disruptive Activities Prevention Act, was brought out in 1985 primarily to counter Khalistan terrorism that had broken out in Punjab and to deal with terror that had spread in other parts of the country. TADA had very stringent provisions, and there were serious allegations that the law was being misused. This law provided for self-incriminating evidence to be accepted in courts. So due to the controversy surrounding TADA, because of the violations that happened under it, the law was allowed to lapse in 1995. Within one decade, TADA was allowed to lapse by the government. It was not extended. Then in early 2000, in 2002, the then Vajpayee government brought out a new anti-terror law to replace TADA, because there was no anti-terror law at that point, and POTA was brought out, the Prevention of Terrorism Act, with almost similar provisions, very stringent provisions, which many saw to be as unconstitutional, against the spirit of the fundamental rights of the Constitution. POTA also had a similar criticism, that it was very stringent, gave tremendous powers to the police and the investigating authorities, and quite often the law was being misused and innocents were getting caught up in this abuse of authority. So because of this controversy, POTA was repealed just within 2 years. In 2004, POTA was repealed by the government. So many critics who criticize PMLA and ED, they equate the law and its provisions with TADA and POTA. So with that, you can understand the seriousness of the controversy and the allegations against PMLA and ED. However, there is another argument which justifies the law, which justifies the powers of the ED, because like I said, money laundering is no ordinary offense. It's not an ordinary economic crime. It's a very serious economic offense. It's a sophisticated crime, and it is essentially a global level scandal that takes place. Because money laundering cannot be carried out by one individual, by one entity. It requires the assistance of several middlemen who help in moving the illegal money around the world, where they place the money in the financial system. Then they layer the money through a set of complex transactions around the world so that they can hide the illegal nature of that wealth, so that they can distance the money from the actual owner who owns that illegal wealth, who has generated that illegal wealth through illegal activities. Once they layer the money through these complex transactions, they integrate the money back into the financial system. And now it comes back as legal wealth, as white money. So to pull off this crime, it requires a global level nexus, a global level scandal where the money is moved from country to country and many complex financial transactions are carried out in the process. So there could be corrupt governments, officials involved in between. There could be criminal groups, terror outfits involved in between. There could be corrupt corporate entities, financial institutions involved. So that is the nature of the crime, and hence it is treated as a very serious offense that threatens the economic stability of a country and the world, and also poses a serious national security risk, and also has social consequences, socio-economic consequences. That is why last week the Supreme Court, when it was looking at the constitutionality of the new amendments, the Supreme Court said money laundering is a notorious offense. The Supreme Court said that money laundering is no ordinary crime. It's a notorious offense and stringent laws are needed. Such extraordinary powers are needed to combat the crime. So that is the justification of the government as well. And the Supreme Court has recently upheld this argument. In the last week of July, right, the Supreme Court ruled that the strict provisions of PMLA is justified. The powers given to ED is constitutional. So there are two sides to the argument here, and that is exactly what we are trying to evaluate, right? So let me just take you through some of the other provisions as well. Please note, ED can start an investigation against any suspect without a complaint or without an application. That is, without even registering the case, without even filing a FIR, the first information report, a ED officer can start investigating a case. See, generally when a crime is committed, right, which is chargeable under CRPC or IPC, the first step for the authorities, for the investigators, is to register an FIR, the first information report, right? That is a mandatory provision. Without that, they can't proceed with the case. The FIR contains the details of the crime, the charges that the authorities are bringing against the accused, right? It provides the details of the crime, and according to law, a copy of the FIR should be provided to the accused. This is the right of the accused. Why? Because the accused should know why they are being arrested, on what charges, what grounds. So under CRPC, IPC, you have these provisions for every other criminal offense. So let's say the police is investigating a case of robbery. Let's say CBI is going to investigate a particular offense. So FIR has to be registered and a copy of that has to be provided to the accused. But ED is the only organization in the country which can carry out an investigation without filing an FIR. It can use the FIR filed by the other authorities, rely upon that, and it can simply file an internal document called ECIR. It can just file the Enforcement Case Information Report or ECIR, which is an internal document meant only for usage of ED. It need not share a copy of this with the accused. So basically, the suspect can be arrested by ED and it need not tell the accused why they are being arrested, on what charges. So that itself is seen as a violation of rights of the citizens. So this is an extraordinary power that has been given, right? Because until recently, until the recent 2019 amendment, money laundering was not seen as a standalone crime. It was not treated as an independent crime. It was always linked with corruption or terrorism or with criminal activities. So once a different investigating authority registered a case, registered a FIR, let's say state police, or let's say CBI, right? Or even NIA recently. Once they register a case and start investigating, if there was a money laundering angle involved in it, then ED would take over the investigation of the money laundering aspect of it. So it wouldn't file a FIR and it would just file an internal report called ECIR. So this was violating the rights of the accused, and that is a major cause for concern. Along with that, PMLA gives the authority to the officer to arrest without prior intimation. They need not intimate, no warrant is needed. The investigating officer can even summon the accused without giving them any reasons. This usually cannot be done in case of other offenses, right? They can summon the accused to the ED's office to come and answer their questions without giving them a reason, without telling them why, without giving them prior intimation or warrant. The accused can be arrested, and once arrested, it is very, very difficult to get bail under PMLA. Especially before 2017. Before 2017, it was almost impossible to get bail under PMLA. Once you're charged with money laundering, it would be impossible and you would be lodged in jail. And after many years, if the case falls apart, you would be released, you would be let off, but you would have spent years in jail unfairly, right? So this has happened in many cases. In majority of the cases, accused have been jailed with no provision of bail, with no option to justify themselves, and as a result, they have spent years in jail, and that is a grave miscarriage of justice. So that is why these powers are controversial. In fact, until 2017, right, if the accused was seeking bail, let's say there is an accused who's charged for money laundering, and if they move a bail application, the court, while deciding on the bail application, it could grant bail according to the law only if it was satisfied that the accused is not guilty. Now, what kind of provision is this? Even before the proceedings happen, even before the prosecution takes place, right? In the initial stages of the case, how can the court determine whether the accused is guilty or not? So basically, the burden of proof, the burden of proving one's innocence was placed on the accused under the law. And it still remains the case in several provisions. See, generally, the basic principle of jurisprudence, the basic principle of natural justice is that you are innocent until proven guilty in the eyes of the law. Here, in certain cases, it is the other way around. You are presumed guilty. Your guilt is presumed by the authorities, and it pushes the court also to presume your guilt, to determine whether you're guilty or not, even before evidence is brought up, even before the prosecution happens. Right? So the accused has to prove their innocence. The burden of proof is on them to show that they are innocent. So that is why the Supreme Court recently struck down this provision in 2017. This provision related to bail, where the court was determining whether the accused is guilty or not, even before the trial, right? This provision was struck down as unconstitutional. But before this, that is before 2017, many cases had been filed, many accused who were eventually not guilty, right? They did not get bail for years together. Years together, they were in jail. And the irony is that for money laundering, the maximum punishment is usually 7 years. 3 to 7 years is the range of punishment given. Many accused have spent 4 or 5 years in jail, and eventually they have been let off because the authorities, the ED, didn't have enough evidence against them. It didn't have a watertight case against them. So essentially, they had spent years in jail, and this was miscarriage of justice. Even bail was being denied to them because of such extraordinary powers. Another important provision is that ED is probably the only central agency, the central investigating agency, which need not seek permission from the government while moving against politicians and government officials. This is quite extraordinary. For example, let's say CBI wants to investigate a corruption case against a government official, a senior IAS officer, or if it wants to investigate politicians or a minister, it has to seek prior approval from the government. Even before it files the case and moves ahead, it needs approval from the government, written permission from the government. But ED is the only central investigating agency which need not get any such approval. Right? It can move on its own against any politician and government officials and investigate any possible cases of money laundering. So some might argue that this is a great power. What's wrong with it? It actually helps ED to go behind corrupt officials and corrupt politicians who are involved in corruption and money laundering. So it is a good provision. But what if the ED is misused? What if the ED is informally informed, right, by the ruling class, by the ruling party, to target a politician, to target a a political party or to target an official who is going against the government, right? So without following the necessary process, without any checks and balances, the ED will move against them, arrest them. Bail is also very difficult to get. Once you're arrested, you're in jail for months together or years together. So that is why this provision is controversial and it is criticized. But the most potent provision of this law is related to the property. It's related to the proceeds of crime. The proceeds of crime, which can be searched, seized, that is basically confiscated and attached. These powers are considered to be extraordinary because, again, the burden of proof here is on the accused. Right? Once ED says that we believe that this suspect is guilty of money laundering, and ED goes and seizes his house, his car, and any other asset he has, right? Maybe stocks, maybe cash in the bank. If it seizes everything, his guilt is presumed, right? Now the accused has to prove that they are innocent. And until then, the proceeds of crime remain attached to the ongoing case. This again is an extraordinary power. Under the law, if let's say a person is in possession of a property, right? Let's say there is a person who has a house, or he owns a private jet, he owns a yacht, right? He has some luxury asset or property with him, or he has a lot of cash in bank. Let's say he has a lot of stocks in the capital market, right? Any asset can be confiscated and seized, and like I said, it's upon the accused now to prove otherwise that they did not procure this asset through money laundering. Is that clear? They have to prove otherwise, that they were not involved in money laundering. So intent is presumed. Now let's also assume that, let's say, this wealth, this property was procured through money laundering proceeds. Let's say there is a driver of Vijay Mallya, right? He had bought a car, and apparently the car was bought by using money which was involved in money laundering, right? Now the driver who owns the car will be arrested, and the authorities will presume, the law presumes, that the driver had the intention to commit money laundering, and he'll be charged with money laundering. He may not even be aware of the crime. Maybe someone else has pushed it on him. And this is the seriousness of this provision, right? The intent is presumed here. If you are in possession of a property or an asset which might be linked with money laundering, even if you don't know about it, if someone else has pushed it in your name, let's say it's a Benami transaction, that's what happens usually in such cases, right? The person who possesses the property is also believed to be involved in money laundering. His intent to commit money laundering is presumed, and the accused has to prove that he had no clue about it. He was not involved in money laundering. Section 22 states, where any property or records are seized from any person under the Act, it shall be presumed that such a person is the owner of such property or records. What if there was a Benami transaction done, right? This is another flaw with the law which is pointed out by many legal experts. It presumes intent on those who possess the proceeds of crime. It is presumed that this person was involved in money laundering. Now finally, this law was amended in 2019, and several changes have been made to the law. Through this amendment, the law has become even more strict. It has become a stringent law today. And the controversy around the amendment is that it was introduced through an indirect route. Instead of pushing a regular bill in the parliament for amending PMLA, the government used the Finance Act to disguise it as a money bill and got it enacted. If you're aware, the same controversy, the same constitutional question exists with regard to Aadhaar Act as well. And the Supreme Court is still looking into the constitutionality of disguising a regular law as a money bill and getting it passed or enacted in the parliament, right? So that is why the 2019 amendment has been very controversial, and its constitutionality has been challenged in court. This was the recent case the Supreme Court was looking at. The last week's ruling the Supreme Court passed was related to this particular case where the constitutionality of the 2019 amendment has been challenged. So the very route through which it was introduced has been controversial, has been problematic. Along with that, it brings about many changes where money laundering is treated as a standalone crime, which it wasn't previously. So now ED can go ahead and investigate any case just by filing ECIR, and it need not wait for an FIR to be filed by other authorities. Previously, it had to wait for an FIR either by the state police or by CBI or by NIA because it was a predicated offense. Now it is an independent crime. So ED has exclusive jurisdiction. Just by filing ECIR without even waiting for an FIR, it can proceed on the case. And the definition of proceeds of crime, right, it has been further expanded to cover even more financial assets. This is actually a good provision because it covers any proceeds of crime that are located abroad as well. This is especially to deal with economic fugitives who have run away from the country, who have hidden their proceeds and wealth abroad. So that is a good provision which expands the definition, the ambit of proceeds of crime, and it deletes few provisions of section 17 and 18 that are related to search and seizure and search of persons, where ED need not wait for FIRs to be filed by the other institutions, the other investigating agencies. So now it is a standalone crime. Without an FIR, ED can file its internal report, its ECIR, and proceed with the investigation and can even arrest the accused. So that makes ED even more powerful. Before it had to wait for FIR from other institutions. Now it need not wait anymore because it's a standalone independent crime. To give effect to this, related provisions under section 17-18 have been deleted so that there is no prerequisite of an FIR. Is that clear? So that is why the constitutionality was challenged. And along with this, PMLA is now providing for non-bailable offenses under certain conditions. In certain cases, if the accused is charged with those provisions, it will be non-bailable, meaning there is no provision of bail at all. And it empowers ED to arrest without warrant. In few specific cases, ED need not justify anything to the accused and to the court as well until it files a charge sheet and brings evidence. Until then, the accused can be held in custody, he can be arrested, and it can be treated as non-bailable in certain cases, in certain categories, right? Another important change which has been brought about by the amendment is that even the concealment of the proceeds, let's say someone is helping the actual culprit to conceal the proceeds, even they will be charged with the full provisions. Let's say someone has moved the money, smuggled the money, right? Someone might have done it for commission. So, or someone might have done it by force, right? Even they would be charged the same way the actual accused is charged. They would be charged with the complete offense, and if proven, they would be delivered the full punishment, just like the actual accused, right? Who might be held guilty as well. So this is a provision again which has generated controversy, because how can you treat the act of concealing a crime as the same as committing the crime? There has to be a subtle difference in the punishment that is given. See, it's not that they're not guilty. They are guilty. They have committed an offense, but it can't be the same as the main offense, right? But PMLA is putting both on the same stage. It's putting it on the same platform. So that is why the new amendments were very controversial. They were challenged. There were many cases filed against it, challenging its constitutionality. The Supreme Court clubbed these cases, took it up for a hearing, and recently, just a few days back, in the last week of July, it upheld the constitutionality of PMLA. The Supreme Court said that such a law is necessary. These powers given to ED are justified because money laundering is a very, very serious offense. So these are the two sides of the argument that you need to understand. On one hand, the ED itself, the government, the court, they're all justifying that this law is constitutional, it is needed, considering the nature of the crime, considering the impact of the crime. But on the other hand, activists, legal experts, they are challenging it on constitutional grounds. It's being said that PMLA and the extraordinary powers given to ED violates fundamental rights guaranteed under Article 20 and Article 21. This is one side of the argument. Is that clear? And that is why this topic was in news. So now the last question. What is the verdict? Is ED being misused? Are these powers too much or are they really needed? To look for answers, we have to look at data. Let's not be biased here. Let's be very objective. Let's look at data, facts. Based on that, we can draw a conclusion. According to data brought out by NCRB, the National Crime Records Bureau, if you look at the number of cases that ED has filed, the number of cases it has investigated, the number of raids it has conducted, and compare this with the conviction rate, the answer becomes pretty evident. Recently, I think it was March 2022, in March, a politician from opposition party, Manish Tiwari, had filed a question seeking few answers from the government regarding PMLA and the raids conducted by ED. In this question, the MP, Manish Tiwari, he wanted to know that how many raids have been conducted by ED, how many cases have been taken up, what is the conviction rate. The government tabled this data in the Rajya Sabha, and according to the data, in the last 8 years, between 2014 and 2022, there has been a 27-fold jump in the number of raids and cases that ED has taken up. It has taken up 3,010 cases as compared to just 112 cases between 2004 and 2014. So this is an exponential jump from just 112 raids and cases in that period, that is between 2004 and 2014, to 3,010 raids and cases between 2014 and 2022. And if you look at the conviction rate is absolutely low. Just 23 convictions have been achieved. Look at the number of raids here. The number of ECIRs filed. ECIRs filed is close to 5,000, 4,900. Charge sheets have been filed only in 993. Only around 1,000 cases have been taken for prosecution. Out of that, ED has achieved conviction only in 23 cases. The percentage itself here shows you how the cases have fallen apart in the court. And why does a case fall apart? Because due to lack of evidence. When you don't have enough evidence, when you don't have a watertight case, that is when your case falls apart. That's when the prosecution falls apart, right? And that itself is an indicator that many of these cases to begin with were not justified. The arrests that were carried out, the bails that were denied were not justified. It was a violation of the rights of the accused, right? So that is what the data shows. And in terms of value, in terms of the money that is confiscated here, the wealth that we are talking about, ED has confiscated close to 1 lakh crore rupees worth of proceeds of crime. Is that clear? So this data is quite helpful in drawing conclusions, and that is why there is a strong accusation that ED is often misused by the ruling parties. See, this is not just with ED, this is not just with the current government or the current ruling party. Since 1950s, almost every Indian government has set a track record of misusing central investigating agencies. This is an unfortunate reality that we are dealing with. Central investigating agencies like CBI, the IT department, now NIA, the National Investigation Agency that deals with counter-terror cases, and ED, they've all been accused and criticized of being misused by the ruling party at the center. Doesn't matter which party is in power, doesn't matter which government, which leaders are in power. Irrespective of that, throughout our history, central investigating agencies are often misused to target political opposition, state governments which are ruled by opposition parties, and this has become a norm. That is why the Supreme Court had passed a scathing judgment a few years back, where it had called the CBI a caged parrot. The CBI had called was called by the Supreme Court as a caged parrot, which blindly listens to the tunes of its masters, which sings according to the tunes of its masters, which is nothing but the government. So there has been a long-standing controversy here that central investigating and law enforcement agencies are often misused by ruling parties for political vendetta. That is, to settle political scores, to target opposition parties, to target even social activists or institutions which might be critical of the government, to target state governments that are ruled by opposition parties. So this is a long-standing issue. It's an issue related not just to ED. The same controversy exists with CBI, IT department, and all the other central law enforcement agencies. But the issue related to ED has acquired a lot of prominence lately because of the extraordinary powers it enjoys. As we mentioned, its powers are even more extraordinary than the CBI itself. That is why this is a very serious issue and the topic has grabbed headlines in the last few weeks. So on this note, I would like to bring my discussion to an end. So I hope it was a fruitful discussion. I hope you got to learn something about the ED. And if you like the video, do let us know by pressing the like button. Share your comments. The comments will act as our feedback. It will help us improve our initiatives and also to know that the initiatives are benefiting you. And without fail, subscribe to the channel. So thanks for watching. We'll see you again next week.